speaking with attorney Steve Halbrook about the Nordyke case in California. Steve, thanks for being with us on NRAnews.com. A big case, and Steve, you're involved with the California Rifle and Pistol Association, authored their brief. Tell us first, Steve, for people who don't know what the Nordyke case is, what is it all about and why is it significant to gun owners?
Well, most of gun owners probably are aware that gun shows are held all over the United States at fairgrounds. It's a public venue where actually shows of all kinds are held, historical, antique, coins, you name it. Your local fairgrounds is a typical venue for gun shows as well. Mm-hmm. There came a time in Santa Clara County, California, where one of the members of the governing council, the county supervisors, said, we don't really like gun shows. We want to do what we can to close them down, and so we're going to pass a law saying that no firearm can be possessed anywhere on any county property. And so they passed that law, and the Nordykes run some of the best gun shows out west in California, and they brought a lawsuit saying that you can't do that, that we're entitled to use that property just like everybody else. And in fact, as the litigation developed, everybody conceded there had never been any problem at any of their gun shows. Nobody had ever been in violation of any law that anyone was aware of. There had never been any accident or crime. So it was basically a vendetta of people who hate the Second Amendment passing a law to not allow people in that county to have a gun show.
And we see this, Steve. We're just covering another story out in California, the sole remaining gun shop in California. San Francisco, excuse me. Thanks, Cameron. In San Francisco, they're trying to put it out of business. The exact same attitude. People who are legal, lawful firearms owners and proponents, they're treated like second-class citizens, like they're evil and they're bad. And it's like, let's do whatever we can to drive this out of business.
That's right, and in fact, that's been going on in San Francisco for some time. They've been making it as miserable as possible to have a federal firearms license and have a gun store there. So the basic technique is to drive the supply of guns, just like if you wanted to violate the First Amendment, you'd try to make it as hard as you could on booksellers, and that's what they're doing with Second Amendment protected activity. So at any rate, what has come out of this Nordyke case, buttressed by the recent Supreme Court decision against the city of Chicago called McDonald, is that yes, hello, the Second Amendment applies in California. It applies to the state of California, to counties and cities there. And then the question becomes, even though it applies, will the Court of Appeals say that the county can still ban gun shows or gun possession on county property? Or will they say that, hey, wait a minute, a fairgrounds is not like the kind of place where you could ban guns with some kind of legitimate reason, like a school or a government building where government workers regularly work, a courtroom, for example. This is the kind of place of fairgrounds is where anybody and everybody goes, and they go there voluntarily. Nobody ever made anybody go to a gun show. Everybody who goes to the gun show is there of their own free will, and nothing happens. They're illegal. So it's basically an attempt to violate the Second Amendment and get away with it.
So just like the McDonald case in the city of Chicago has ramifications all over the country, there's a possibility for that in the Nordyke case, and tell us in what way.
Well, the Court of Appeals that supervises the state of California is really the biggest one in the nation. Many of the states out west are under the U.S. Court of Appeals for the Ninth Circuit. So if it rules that, despite the Second Amendment applying there, that the county can ban gun shows on county property, and again, we're not talking about the county police station or someplace like that. We're talking about the fairgrounds. If the court says that, then I mean, basically, any place is in danger of being banned as far as gun shows are able to take place. It's not a kind of sensitive place or sensitive type of property where traditionally there's restrictions on who can enter the property or what can be done on that property. If a place is a government building, a military post, or a fire station, not anybody and everybody can just go in there and do whatever they want to do. But if you've got a fairgrounds or a place like that where private individuals rent the place to carry on certain functions, then it's a very significant problem under the Second Amendment if a governmental body can simply ban gun shows or any other kind of show there, particularly in the context here. The fairgrounds in Santa Clara County, they allow the Scottish Games to take place there, which use black powder blank guns, or I guess black powder guns without projectiles, to have reenactments, and I'm sure that's a lot of fun. I like to go to things like that.
Yep.
And it's a fairground, so they have fairs there. At any rate, the whole issue boils down to, now that it's decided by the Supreme Court that the Second Amendment applies to states and localities, something, by the way, that you and I have known all along. The question is going to be, how serious is that right going to be protected or respected?
Steve, yesterday in the city of Chicago, a bunch of lawmakers got together to talk about closing the gun show loophole. Now, talking about Nordyke, and Nordyke is nothing but a gun show case. Can you explain, once again, the fallacy of the gun show loophole?
Well, there's no loophole. That term irks me because the law is the law. So if the law says you can drive 55 miles an hour, if you're going 55 miles an hour, it's not a loophole. If it says that a shotgun barrel has to be at least 18 inches and you've got one that's 18 and a half, it's not a loophole. So as it exists today, there are federal laws governing what takes place at gun shows, and by and large, it's the same law that applies outside of gun shows, namely that certain people are prohibited from firearm possession, people who are convicted felons, and law-abiding people can, in accordance with federal law, buy and sell guns. And part of that entails background checks if you're buying from a licensed dealer, a prohibition on people transferring guns if you're from different states. There's all kinds of laws and regulations. And then at the state level as well, some states have laws especially governing gun shows, like California has a lot of requirements. So there's no loophole about gun shows. It's a gun show is a wonderful experience. It's like being able to go to a museum where you can actually touch things and pick them up and
buy them.
Look at things. You go to a gun museum and things are behind glass.
Right.
You go to a gun show and you get the permission of the person at the table.
Right.
You can look at the engravings on the gun. They might be from the 1700s.
Yep. Cool.
And by the same token, if it's a modern cartridge gun, it might be a semi-auto rifle made in 1905 by Remington, or a completely modern new gun. You can look at it. You can examine it. And it's very educational. People come together for not just to look at guns, but to discuss political affairs. That's another reason that people who hate the Second Amendment are against gun shows. It's a place where ideas are exchanged, and you talk about candidates who are for you and those who are against you. So there's no such thing as a loophole. Mm-hmm. The law is the law, and if people are abiding by the law, they're not evading the law, they're not undergoing some kind of loophole.
Now, Steve, we were both on the steps of the Supreme Court after the McDonald case was decided upon, and we heard Paul Helmke and the Brady campaign folks talking about how there was going to be this orgy of lawsuits and the NRA was going to be out of control. And you as one of these NRA lawyers, do you feel out of control? I haven't seen an orgy of lawsuits as of yet. What is his crystal ball broken?
I'm not sure. Maybe that'd be a lot of fun to have an orgy of various kinds, right? But most of us are pretty restrained, responsible people. We are litigating in selected places, both before that decision and afterwards. After the decision, as you know, the city of Chicago passed even worse regulations about guns, making it as hard as possible to be a gun owner.
Shocker.
Worse than before as to long guns. Mm-hmm. And the District of Columbia had done the same thing 2 years ago. We're
Mm-hmm.
litigating that in the District of Columbia. So we're going to stand up for gun owners. We're not going to be contesting laws against gun possession by violent criminals. We're the ones responsible for getting those laws passed.
Yeah, and Steve, if you're doing what is necessary, they're passing these laws when these decisions come out, so you need to fight them.
I think that if you look at its behavior in the past decades, the NRA has been a model of restraint and a model of standing up for Second Amendment rights at the same time in selecting cases to litigate, and I think you'll see the same thing in the future. Mr. Hemke, they see an orgy of crime, an orgy of lawsuits, an orgy of everything coming, but the sky hasn't fallen yet, and it never will.
Steve Halbrook, thanks for keeping it real with us. We appreciate that's why we love talking to you, sir. And keep us updated on the Nordyke case. We appreciate it. And thanks for coming on today on the NRAnews.com. We'll talk to you soon.
Always my pleasure, John. Thank you for having me.
Thank you.